In the year 1215, the feudal barons forced King John of England to sign the Magna Carta Libertatum. The Magna Carta protected the privileges of all free men and ensured that they would only be subject to the law of the land. From that day forward, in order for the king or his courts to exercise authority over a free man's life, liberty, or property, that free man had to forfeit his lawfully protected privileges by committing an action that caused injury, damage to property, or violated an agreement he knowingly and willingly made. This law of the land is now called the Common Law of England. Being subject solely to the Common Law of England was the base privilege the Magna Carta was designed to secure. Sir William Blackstone, a leading authority on the Common Law of England, defined crimes and misdemeanors as a private wrong and somewhat more. According to the English common law, there is no crime unless another free man has suffered injury, property damage, or a broken oath. The privileges secured by the Magna Carta ensured that free men would not be deprived of life, liberty, or property unless they committed some act causing direct or actual injury to another free man. Since the English definition of free man included lords but not commoners such as serfs and foreigners, free men would from time to time find themselves in custody for laws applicable only to commoners that regulated their behavior, property rights, and other liberties. Upon discovering the imprisonment of a lord, a writ of privilege would be delivered to the sheriff, declaring the lord's immunity from prosecution and immediately securing his release from custody. Every powerful government had an eye towards expansion. The British were no different. In Britain, the political authority, the government, essentially set its sights on populating this territory with its colonists. And most of the people that went over were people of a lower class. Because really, if you were a lord in Britain and you had all of this land and all these people working for you on your land, serfs and likewise, why is it that you would want to travel for months to a whole nother land in order to experience none of the accoutrements that you have built up for yourself in Britain? You wouldn't. Now, individuals who are looking for a better lot in life certainly would travel over because they want to establish for themselves opportunities. They wanted to become the lords in America. So Britain, an extension of its political authority, creates a channel for these individuals to traverse to this new land under the protection of the British government. The one thing we need to remember is that a government can only protect what's in its field of vision. And its field of vision is created by the founding document. In America, it's the Constitution. So that government, when it looks at people within its territory, it looks at them in the context of what that document set out. Either they fit the designation or they do not. You are either the person described in this document or you are not. And it is my job and objective to protect the persons described in this document. And in colonizing it, this massive political authority that works together now comes into contact with these tribal factions, these Indian tribes that are fragmented. But of course, the British government being well-established, well-formed, well-funded, and well-armed, they were able to overrun the fractured tribal governments of the Indians and essentially push them off the land. But again, this is all done under the guise of the political authority of Britain. Okay, let's be realistic about some things. First of all, with any group of people, 1% to 3% of that is made up of psychopaths. And these are individuals with no remorse. They actually believe in every case that the ends justify the means. In order to believe that you can own somebody else, you have to be a little bit psychopathic. These are the individuals that thought to themselves like, hey, I can get ahead. I can create an economic advantage by going down to Africa and picking up some slaves, taking them over and having free labor. As it relates to slavery, as many white villains you had black villains. Because the reality is that these Africans that were pulled out from within Africa, a lot of the times they were brought by their own people to the shores and sold. They were productized by other Africans. And it's just like with anything else. When you occupy a continent and you have all of these tribal governments, these small political authorities, they have these skirmishes, they have these controversies, they have these fights, and ultimately, one political authority overtakes another one, and those people become its subjects. Ultimately, what these political authorities that had conquered people did is they took them as slaves, and then they sold them. So now you have these black psychopaths, these African psychopaths, who are running and they're capturing their fellow Africans, not their fellow Africans in the sense of one cohesive political community, but fellow Africans in the sense that, hey, look, we all share and occupy the same continent. They were taking these people, productizing them, and then they would take them to the shore, and then they would sell them to a British colonist and or someone engaged in the slave trade. The political authority of Britain, of course, did not recognize them. That government was not set up to save or protect slaves that were conquered people and sold as property. They were seen as enemy combatants to that political authority that captured them. These people, these African slaves, were then left stateless with no political allegiance or a political allegiance to a political authority that couldn't protect them.
When you think about the British colonies, you have to think of them as you would think of a franchise, whether a McDonald's or a Burger King. The reality is that when they were granted a charter by the king, they essentially took all of the legal system from Britain and applied it directly on the territories and the colonies. Therefore, on land, you had the common law, the law of the land, the thing that was protected by the Magna Carta for all free men. You also had the law of equity, which regulated contracts, the interaction between people, both explicit and implied agreements. And then lastly, on the sea, Admiralty Maritime Law. This was civil code, Roman ecclesiastical law that was made up entirely from the mind of man. If they decided something was wrong, they declared a law stating such, not because there was any moral turpitude, but simply because they just didn't want it to happen. One of the privileges of the Magna Carta was that a British subject could go anywhere within the British territories, and they would have the same rights as if they were at home. The same thing applied in the colony. Those privileges and immunities that they possessed, they could take with them all throughout the 13 colonies that were under a British charter. Unfortunately for the slaves, who were considered as property, they didn't have that right. They were essentially limited to only go where their slave masters allowed them to. Remember, the colonial legislation didn't recognize the slaves as British subjects. Therefore, they didn't protect them. They simply were subject to the whims of the legislature. Because remember, they were simply articles of commerce. The common law didn't apply. They were simply purchased on the shores of Africa, brought over as property under the Admiralty Maritime Law, the law of commerce, the law of merchants, and when they reached the territory, because they weren't British subjects, they were not converted into the protection under the common law. Therefore, Admiralty Maritime Law operated on them specifically and directly. Over time, each of the colonies developed specific doctrines to deal with slaves and their offspring. The most prominent doctrine was the partist doctrine, which essentially said that which comes from the womb assumes the status of the womb. That was a significant modification to the common law. In England, under the common law, if you were born in a territory, you were automatically a subject to that political authority. However, for the psychopaths, they had a different thought in mind. What they wanted to do is have a continuation of ownership from the mother to the offspring. So they created what was called the partist doctrine. The partist doctrine allowed them to utilize Admiralty Maritime Law to exempt their offsprings from the rules of common law in Britain. So they essentially applied a status in Admiralty Maritime Law to a slave as property. They wrote a law, and they actually had to write a law in order to modify or to override the common law. Because absent this modification, they would not have the ability to change the status of the offspring, because everything automatically defaults to the common law when no other law exists. In this particular case, what they said is that we never want the offspring to be subject to the common law, because then we could no longer continue to legally hold them as property. Because under Britain's charter, they would be subject of the king, therefore afforded the protection, certain liberties that were provided. As we stated earlier, free men included lords and barons. They didn't include serfs. So the serfs that came over had limited liberties, but they still had more privileges than the slaves did. So now we move back to the reality of the British settlers who were serfs in Britain and thought they would come to the new colonies and become free men. The reality is that didn't happen. Prior to the American Revolution, Britain passed what some called the Intolerable Acts. And they said things like, it's unlawful for more than 5 colonists to get together for town hall meetings. There were curfews, there were liberties that were summarily abridged, such as the right to bear arms. They were quartering soldiers in the houses of these colonists in the new Americas. And then finally they got fed up and they said, you know what? We don't need this anymore. We're tired of being oppressed. And they signed the Declaration of Independence, and they essentially said that we are declaring our own sovereignty. We are no longer subjects. We believe that we can attain our rights directly from God. We don't need an intermediary called the king. All men are created equal. Now, of course, given the fact that they're sitting there with slaves, that's a little bit hard to believe, but all men are created equal except our property. So now they're sitting here with these slaves declaring sovereignty, independence from the King of England, direct relationship with God, who gives them their inalienable fundamental rights. And they say, hey, we're willing to fight for ours. So British send ships over and there's a fight, it ensues, there's a battle, and we end up winning. Now America's free. So they get together and they say, oh, we need to create these Articles of Confederation because now we're no longer subjects of Britain. We're now citizens. We're no longer colonies. We're old franchises. We're not the British franchise anymore. We're now American states. It's like a McDonald's franchisee saying, oh, we're taking the arches off. But we're going to keep everything. We're going to keep the processes. We're probably going to still buy from the same people. We're going to run our shop just like it's a McDonald's, but it's just not going to have an M on it. And there's not going to be any employees. Everyone's going to be an owner. They became a citizen in the state. And as a citizen in the state, they created this constitution. And this constitution was to reflect what their relative rights were. They all chose not to be serfs. They chose to be treated like free men. So they use these terms like life, liberty, and the pursuit of happiness. So what is life? It's the right to defend yourself when somebody attempts to take your life. What is liberty? Liberty is the freedom of movement, the freedom of speech, the freedom to own property. In the pursuit of happiness, well, that's simply the right to utilize your property for its intended purpose. So if you have land, you can utilize it to cultivate whatever it is you choose. That's what a free man had the capacity to do. There wasn't any federal laws saying that you can't grow marijuana on your land. It was simple. It's right to life, liberty, and the pursuit of happiness. As long as I don't damage anybody's property or injure anyone, then I have the right to do whatever it is I choose. So they enshrine this term, life, liberty, and pursuit of happiness, in all their constitutions. And they had this Articles of Confederation that said, okay, we all need to get together and we need to work it out collectively, because who knows if Britain might come back. But then we also have France over here that we have to deal with. So we need to kind of muscle up a little bit, and we can do that better if we're together. So they create the Articles of Confederation, which ultimately didn't work out. And they had to create a more perfect union. So they created the Constitution for the United States of America. And when you read it, it's very specific as to who it applies to. In the preamble, it reads, we the people of the United States, not we the people of the United States and the territories, not we the people of the United States, the territories, and Britain, but very specifically, we the people of the United States, which means that it was individuals that belonged to the collective political communities of the 13 colonies that became states. Those people are the ones that those state governments were set up to protect life, liberty, and the pursuit of happiness for. And then they all got together through their representatives, and they created this federal constitution, the United States Constitution, which was to protect the rights of we the people of the United States. So of the states united. So that's who the Constitution is looking at right now. And we talked about this, but there's only 2 ways that you could become a citizen of a state. One was through naturalization. And at that point in time, each state independently naturalized people. So New York would naturalize people to become New York state citizens. But naturalization was one way. The other was through birth. So according to the common law, by birth, you became a citizen of that state. So now you're here and you have this constitution, this eloquently written constitution, we the people of the United States. And then it gets very specific as to what its intentions are. Number 1, to form a more perfect union. They want to create something separate, outside of themselves, which represent the collective bodies. They're not all merging. It's as if you had a union. For example, you work for Chrysler, I work for Ford. We work for two separate companies, but we both belong to the United Auto Workers Union. That's an entirely separate entity from us as individuals, as well as from our companies. But that United Auto Workers Union represents each of us in our interactions. So therefore, we, the people of the United States, Texas is Chrysler, Arkansas is Ford. The federal government is the United Auto Workers Union. Now, the only way that I could be a part of that union is if I'm from a state, if I'm a citizen of a state. The goals and objectives of the Constitution were very specific. One was to form a more perfect union. They needed to establish a mechanism that allowed them to cooperate together in order to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and most important, to secure the blessings of liberty to ourselves and our posterity. Government's objective was to shine a light on these specific issues for these specific people, the people of the United States, no one else. That's who the government could take cognizance of. The Constitution is essentially a set of rules. It establishes an absolute rule of action and decision for all departments and officers of the government. Article 1, that's the rules of action for Congress. Talks about what Congress can do and how they do it. Article 2, rules of action for the executive branch. Talks about the president, the vice president, and how the executive branch operates. Rule number 3, that sets the rules of operation for the judiciary branch. Articulates the type of laws that are applicable in this country. Common law, equity, amity maritime. Talks about the Supreme Court and how it's going to operate. And then the 4th is the rules of action for the states. It talks about how the states are going to operate and how the federal government is going to secure the blessings of liberty for ourselves and our posterity. Now, remember, when it's saying this, they're talking about state citizens, someone born or naturalized in a state. So now what we have here is we have a comprehensive document. And in that comprehensive document, Article 4, Section 2, Clause 1 contains one of the most fundamentally misunderstood clauses in the Constitution. It's called the Privileges and Immunities Clause. And it says, the citizens of each state shall have the privileges and immunities of the citizens in the several states. Now, many people have asked, what does that mean? But it's quite simple. But before we go into that, we're going to talk about what it says specifically. The citizens of each state. So you have to be a citizen of a state in order to be entitled to all privileges and immunities. Are you a citizen of the state as we contemplated when this Constitution was written? They're talking about state citizens, someone born or naturalized in a state. So now, if you're naturalized there, you had to be naturalized according to the uniform rules of Congress. So Congress decided how you were to be naturalized and who, specifically what classification you had to meet. And early on, it was simply just white people that could be naturalized. Europeans, they could be naturalized. There was no mechanism for Asians or Africans. They were very specific about that. But Congress always had the right to change it. If you weren't born there and you weren't naturalized into a state, you didn't fall underneath this clause. But if you were a citizen of the state, then you have to go to the next part of this clause, which is are entitled to. An entitlement is the claim. It's not something that is automatically assumed. It's something that you have to demand. You have to declare it. I am a citizen of the state, and I'm claiming my privileges and immunities. That's what people misunderstand, because you see, the privileges and immunities, all the way back to the Magna Carta, protected personal rights. And these personal rights are only rights that you can claim as an individual. Because if we assumed everybody had them, then we'd have no mechanism for legislating people's behavior. Now, of course, a lot of people will say, well, why legislate people's behavior? And my response would be, well, because sometimes you have to. When someone comes into your house, you have to tell them, hey, look, you can't walk on my carpet with your shoes on. That's legislating people's behavior. Now, I'm not trying to say you're not free, but you do things differently where you live. Where I live, you need to take your shoes off before you walk on my carpet. So it's very similar to an immigrant coming over from Mexico. They do things differently. If someone comes from Europe, they drive on the left side of the road. We drive on the right side of the road. You do things differently. I need to be able to legislate your behavior because you don't understand our customs. You don't understand the way we do things. So I need to be able to tell you. So therefore, if you have a privilege and immunity, it's a personal right, and only you can claim it by declaring your status and demanding that right be given to you. Now, the people who have that status are citizens of each state, and they have it in any state they go to, shall be entitled to the privileges and immunities of the citizens in the several states. So no matter where they go in this union, as long as they're within a state of this union, they are protected. Their fundamental rights are protected. And that fundamental right, it's simple. It's to be protected by the common law and only subject exclusively to the common law. Your equation is simple. If I haven't damaged anybody's property or injured anyone, I have immunity to that law. In Article 4 of the Constitution, where it sets rules for the states, one of the rules is that you can't encroach upon this fundamental privilege, which is to be immune from anything except the common law. And that, in a nutshell, captures your life, liberty, and the pursuit of happiness. When we look at it, with the citizens of each state, what we see is that government's beam of light only shines down on certain individuals. The individuals it recognizes. Part of that is that it recognizes the psychopaths. Even though they went over there and grabbed some slaves and brought them over, they matched the lineage. They were there when the colonies became states and everybody all at once became naturalized. And then everybody born after the states were formed became a citizen of that state. And as a citizen of that state, they became an automatic member in the union. Slaves, on the other hand, were never given the access to the common law. They were subject to admiralty maritime law, the codes that man made up, that he decided that this is how I want it to be. No, because I say so. Not because it's the law of the land, because I say so. So now you have a slave sitting here in the darkness, untouched by the light, because he's presumed to have a political allegiance someplace else, and he is considered a piece of property, the Partis doctrine. He has no rights. And in fact, the Dred Scott case, he's asked whether an African slave is considered a constituent member of we the people. He says, no, they're not. And he says, a Negro of the African race was regarded as an article of property and held and bought and sold as such. That's what the Partis doctrine said. Now, black folks could be mad about that. They could be upset. But, when it comes down to survival of the fittest, at the end of the day, your political authority lost to another political authority. They then took you and sold you to somebody. So at the end of the day, it's survival of the fittest, and its perpetuation was the perpetuation of ignorance and stupidity. But it is what it is, right? So now we're here with no political allegiance, no protection from the states, no protection from the federal government. Now, don't get me wrong. Now, not every state adopted this doctrine. There were northern states that had free black men running around. And the rub for everyone was that, if one of those free black men comes down to our states, they have the right to carry guns. So in an 1857 Supreme Court case, Dred v. Scott, Supreme Court Justice Taney stated that if former African slaves were citizens under the Privilege and Immunities Clause, Article 4, it would give them the right to enter every other state whenever they pleased, singly or in companies, without pass or passport, and without obstruction, to sojourn there as long as they please, to go where they please at every hour of the day or night without molestation, unless they committed some violation of law for which a white man would be punished. And it would give them the full liberty of speech in public and private upon all subjects upon which its own citizens might speak, to hold public meetings upon political affairs, and to keep and carry arms wherever they went. And all of this would be done in the face of the subject race of the same color, both free and slave, and inevitably producing discontent and insubordination among them, and endangering the peace and safety of the state. Let's move away from the racially charged nature of this comment to look at specifically what it's saying. What Justice Taney is doing is he is defining the Privilege and Immunities Clause for you. The citizens of each state shall be entitled to the privilege and immunities of the citizens in the several states. He is telling you that that clause protects your right to bear arms, protects your right to keep and carry arms wherever you go, to hold public meetings upon political affairs, to give full liberty of speech in public and private upon all subjects upon which its own citizens might speak. He's defining what that clause in the Constitution protects from state infringement, because they had what were called the black laws. And the black laws essentially said, no colored person shall carry a weapon. No colored person shall meet when there's more than 2 or 3 of them at any given time. Those were the black laws. Now, Taney is telling you that, look, all of those restrictions are not applicable because as a citizen of a state, you have these privileges and immunities, and those can't be taken away from you by law. So if there is a law that exists and it's applied to you, simply stand up and say, hey, that law doesn't apply to me. I'm a citizen of the state. I was born here, free man. I think I'm going to take a pass on that. I'll let you give that charge to someone else, please. Thank you. But Taney wasn't the only one who spoke on this, who defined the Privileges and Immunities Clause. In 1821, Delaware Chief Justice Johns interpreted the Privileges and Immunities Clause to be such only as belong to the citizens of the several states, which include the whole United States, and must be understood to mean such privileges as should be common or the same in every state, to restrict the power of Congress as to legislation, so that no privilege or immunity should be granted by it to one citizen of the United States, but such as might be common to all. The privileges secured are not such as are given to citizens in one or more states by state laws, but must be such as a citizen in several states, that is, in all the states, are entitled to. He's saying, if you're a citizen of one state, you're entitled to these privileges everywhere you go. You're entitled to these immunities everywhere you go in the Union. Another case, 1797, Judge Samuel Chase, signatory to the Declaration of Independence and Supreme Court Justice, wrote in reference to Article 4, Section 2 of the Federal Constitution, the inquiry as to the effect of a law of any state will not be whether it makes a discrimination between citizens of the several states, but whether it infringes upon any civil right which a man of civil society must enjoy. It secures and protects personal rights. Now, this guy is as close to the Constitution as you can get. Justice Samuel Chase was a signatory to the Declaration of Independence. If he doesn't know what the Constitution means, then I'm afraid we're in trouble. But that wasn't it, because there is a articulation of the Privileges and Immunities Clause that's more fundamental. In 1824, Justice Bushrod Washington, nephew of President George Washington and member of the Supreme Court, defined privileges and immunities as those privileges and immunities which are in their nature fundamental, which belong of right to the citizens of all free governments, and which have at all times been enjoyed by the citizens of the several states which compose this union, from the time of their becoming free, independent, and sovereign. They may, however, be all comprehended under the following general heads: protection by the government, the enjoyment of life and liberty, with the right to acquire and possess property of every kind. With the right to possess and acquire property of every kind. And I'm going to read it one more time. With the right to acquire and possess property of every kind, and to pursue and obtain happiness and safety. Justice Washington essentially said that clause guarantees you life, liberty, and the pursuit of happiness. It guarantees you protection by the common law. It essentially states that it's of no consequence what laws they write. You are immune from them. Those are special laws applicable to special people. They're applicable to people who we cannot presume understand our way of life, our customs. But if you were born here in this state, the presumption is that you are, and you understand it, and you're subject only to the law of the land, to the common law, as it came from England and has been modified by the colonies and modified by the states, up until the time the Constitution was executed. Bushrod Washington today would laugh at a possession charge. You're holding a blunt. Bushrod would say, man, why don't you have 6 pounds? Because you have the right to possess and acquire property of any and every kind. We look at this, the Privileges and Immunities Clause, and what it represented and what it protected, and we say, okay, so what happened? And I can tell you what happened. The psychopaths, the individuals who are willing to win at all cost. They ultimately started a civil war. It was fought and it was won by the North. And with the Civil War came the 13th Amendment. And the 13th Amendment did something that was critical. It changed the way states operated. It essentially said to states, you no longer have the right to create laws that modify the common law as it relates to the status of people in your territory. It abolished the Partis Doctrine. It removed from the states the ability to define someone's status at birth. So now the common law prevailed again. It protected all people who came within the territories of a state. It essentially said that no longer can you make Admiralty Maritime Law. No longer can you create international law and have it affect the offspring of human beings. Not only is there no more slavery, but you no longer have the ability to do that. The partist doctrine shall be no more. So now, it didn't matter whether you were black, you were white, you were Asian, didn't matter. It was of no consequence. Because now, if you were born in the state, you were a citizen of that state. Because the status of the mother can no longer affect the status of the child. This became a fundamental shift in the law of the land. Now there were still two ways, one by birth, and the second was through naturalization. And again, all the way up through this time, states were still naturalizing people. You could still naturalize someone as a Texas citizen. But now the Civil War is over. All the slaves are freed, and you have a problem. The problem is that you have these freed slaves who do not belong to a political community because the 13th Amendment doesn't act retroactively. It doesn't act backwards. It can't go back and change things. Because if you imagine if you had laws that could go back and change things, you could come out of the house in the morning with green shoes on, and then at 5 o'clock they could pass a law saying it's illegal to wear green shoes. But you took yours off at noon, but they'll say, hey, look, you were wearing them at 8 o'clock this morning, so we're going to take this law that we didn't even pass until 12 hours later, and we're going to apply it to you, and we're going to send you to jail for wearing green shoes. Laws don't work retroactively. So the 13th Amendment didn't work retroactively. It didn't all of a sudden fix the situation for those individuals who were born outside of the political authority subject to the partist doctrine. But going forward, any person, anyone born in a state was a citizen of that state, regardless of race, creed, or color. Now, the rules of naturalization, of course, at the end of the Civil War were still the same. And it wasn't until 1868 that they actually allowed for Africans to be naturalized. And the reason they did that is because they looked at this problem that we have all of these slaves who are not a part of any political community. And we need to somehow bring them into the fold, give them protection. Because right now they're wandering around, going from state to state, seeing which one has the least oppressive laws. And in order to give them free access to this land, this territory, this country that we brought them to, we have to figure out a way to help them. So obviously the natural thing would have been to have all the states immediately naturalize them, right? Legislation saying, hey, you all are immediately naturalized and you are now citizens of the state that you're in right now. So if you're in Texas, you're a citizen of Texas now. From now on, just come sign up on the books. But they couldn't do that, see, because, of course, the southern states didn't want to give them rights. They didn't want them to have the ability to protect themselves in court. So the federal government is sitting there looking, saying, hey, it would be easy if they just naturalized them. But they couldn't force them to do it. They could set the rules by which they could, but they couldn't say, naturalize those people now. So as these slaves are running around the country, freed slaves, these free men who are now standing upright, are running around the country looking for the place with the least oppressive laws, the federal government says, oh, wait a minute, I have an idea. The Constitution gave us the exclusive legislative jurisdiction over the District of Columbia. So not only are we a national government who deals with the international community on behalf of the states, but we're also a territorial government. We have a territory. We are a political authority over a territory. So the first thing they tried is they said, okay, well, we're going to write these civil rights laws and see if we can get the states to abide by them. So the civil rights laws are written and the states look at them and say, this has nothing to do with us. You have no jurisdiction in our territory. We do what we want to in our states. You have no jurisdiction here. So the federal government is like, wow, okay, that didn't work. What next? Oh, got an idea. We have our own territory. We're the United States government, and D.C. is under our jurisdiction. What we say there goes. So what we're going to do is we're going to create a United States citizen. So they create a United States citizen, a citizen of the federal government. And they say we can naturalize them into being a United States citizen. And then we're going to force the states to respect them wherever they go before we admit them back to the Union. So they create a United States citizen, a citizen of the federal territories, because they were the political authority there. They could do that. Now, the one thing you have to remember is that the Constitution, again, only contemplated states. We, the people of the United States. We, the people of the states that are united. Article 4, Section 2, Clause 1, the Privilege and Immunities Clause says the citizens of each state. So now you have these new citizens who are not citizens of a state. They're citizens of the federal territory, which is not a state. It's not recognized as a state under the Constitution. So everything preceding that doesn't apply to them. The Constitution doesn't protect them. They're simply citizens of the United States. Okay, cool. Because you weren't contemplated in the original document, we can't retroactively contemplate you because your status didn't exist then. So the forefathers, when they wrote the Constitution, couldn't contemplate this now. I can't go back and infuse that into their brain some 100 years later. It's not possible. So now we're sitting here and we have these citizens of the United States, but under the Constitution, they have no rights, they have no protections. So they write this amazing amendment, remember, to solve a temporary problem. Because the problem is only temporary because these former slaves will ultimately die off. And there'll be no more need for this because anyone born after this in a state is a citizen of that state. The state can't deny it anymore. They can't fight it. It is what it is. So we're creating the 14th Amendment to solve a temporary problem. So here we are in the creation of it, and the 14th Amendment says this: all persons born or naturalized in the United States are subject to the jurisdiction thereof, are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Let's take a look at what this wordsmithing means. So if we look at the first section, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So what they did is they just made a distinction between two places. They're citizens of the United States and of the state wherein they reside. So they did two things. One, they drew a distinction between the United States and then the states. So you know that this is a different physical locale. It's the District of Columbia, so of course it is. And the second thing they did is they created a citizenship in a state based upon residence. So now before, where we had the common law classification of citizenship based upon birth, and then we had the legal from Congress, naturalization, and then the third now is residence. So let me get this right. So if you are a citizen of the Federal Territories, which is the United States, D.C., it's called the United States because it's the United States government. So you're a citizen of the United States, just like you're in Texas, you're a citizen of Texas. But if you're a citizen of the United States, the Federal Territories, and you reside in a state, you are now a citizen of that state based upon residency. Okay, well, that created a specific class of citizen, a residency-based citizen. Now, remember, the law reflects all of this. So then it goes on to say is that no state shall abridge the privileges or immunities of citizens of the United States. First of all, it's privileges or immunities. You have to choose one or the other, versus privileges and immunities, which is in Article 4. But it says, no state shall abridge the privileges or immunities of citizens of the United States. So now we got to look, okay, now what are these privileges and immunities? They're clearly not the same. You don't have the same privileges and immunities that the forefathers essentially created, because the debate in Congress at the time that this amendment was passed was that, hey, here's the problem. These people have been in servitude for 200 years. They've lived in outhouses, not main houses. They were savages where they came from. They didn't wear clothes, right? They drove on the left side of the road. We drive on the right side of the road. They're in a state of pupillage. We need to kind of bring them along slowly to become accustomed with the way that we do things, because the idea is that they weren't born here. So we need to give them rules. You can't wear your shoes in my house. Leave them at the door. So they intended for their liberties to be limited by law because they were in a state of tutelage. They were pupils. They were like going to school to figure out how it is to be American, because remember, these were people who were born outside of the political authority of the states. They were nomads. The presumption was that they were born outside of it and that they had a whole different way of life. So they said, okay, so the privileges and immunities, we shall write civil rights legislation, which will define that. So now when there's a civil rights violation, we say, oh, you didn't violate my civil rights were given to you by civil rights laws. You didn't violate your civil rights. They violated your fundamental rights if you're a state citizen. But if you're a citizen of the United States or a citizen based upon residency in the state, then they violated your civil rights because that's all you have. You see, so they created this class in the states called citizens based upon residency. And then they gave you privileges and immunities by the Civil Rights Act. Then they go on to say, nor shall any state deprive any person of life, liberty, or property without due process of law. Now, for the Article 4 state citizen, they give you have the right to life, liberty, and the pursuit of happiness. In the 14th Amendment citizen, they say, nor shall any state deprive you of life, liberty, or property without due process of law. Well, you don't have a right to all this stuff, but we won't take it away from you unless we come with the legal process to do so. Therefore, you'll be well informed that we're taking them away. You don't have to forfeit any rights or anything. You don't have to do anything specific. We'll just give you notice. Let's give you notice when we're taking things away. So as long as you have due process, proper notification, you don't have the right to anything. The only thing you have the right to is notice, a legal process that we think is okay, right? So their rights were limited. So one of the last clauses that's in the 14th Amendment is that no state shall deny to any person within its jurisdiction the equal protection of the laws. So they come with this new term, equal protection. What is equal protection? Well, equal protection is essentially saying, okay, we have these class of citizens called United States citizens. You represent a class. And then we have this other class here called natural born and naturalized state citizens. So we have two separate classes. Now, we're going to equally protect all the United States citizens, and we're going to individually protect all the natural born, naturalized state citizens. So if you were born and naturalized in the United States, that federal territory, you will equally be protected against violation of your civil rights. And on the other hand, if you are natural born citizen of a state or naturalized into a state by a state, then we will protect your rights individually, your personal rights. You can enforce them. These are fundamental rights that you have. These aren't civil rights. Law doesn't give them. Law can't take them away unless you do something to forfeit them. But we'll protect them individually. So there's a distinction. There's one is equal protection, and the other one is individual rights. Because the only way that you have a civil rights claim is that if you can prove that it was done based on some level of discrimination within your class. So if it's done to all black, white, yellow, and green people, then there's no civil rights violation. There's only civil rights violation when it's done just to black people or just to white people within that class. There has to be some level of discrimination, or it could be gay people, right? Because your rights are derived from the federal legislation. They define your rights. At the state level, your rights are defined by God, and no one can take them away from you. And they're protected by Article 4, Section 2, Clause 1 of the Constitution. So as you figure out where you sit and where you reside, it's come to a point where they've made everybody believe that they're a United States citizen and then a state citizen by residence. Because when you go into a court, the court operates with a blank sheet of paper. Prosecutor writes a charge down. That charge has a certain number of presumptions that are associated with it. And one of those presumptions is that you're subject to their law. And unless you stand up and claim and make a declaration, claim what you're entitled to. Excuse me, there's a mistake here. I'm a natural born citizen of California. I'm entitled to Article 4, Section 2, Clause 1, privileges and immunities. I think I'm going to pass on that charge. Now, of course, that's not the process, but that's essentially what it is. You have to claim those rights. So what happened right after the Civil War is they started coming out with these black laws because now everybody's free. The 13th Amendment has freed all the slaves. So they started writing these laws. No colored person shall bear arms. No colored person shall be out after 10 o'clock. No 2 or more colored persons shall meet in any public place. No 3 or more colored persons shall meet in their homes. So when the 14th Amendment comes out, it says, oh, whoa, wait a minute. They have all been naturalized. They're all now federal citizens, citizens of the United States citizens. And when I say United States, I mean our federal territories that we have exclusive jurisdiction over. They are our citizens now. And you're going to respect them when they're in your state, when they reside in your state, because you're going to consider them your citizens only to the extent that you can't abridge the rights that we gave them. But we didn't give them any rights. We just gave them civil rights. And we said we won't discriminate them against them based upon class. So now you're now traversing the country and you have these limited sets of rights that you've been given. So you're standing here and you're being accused of things that aren't consistent with the common law. But the way the law is written, it says no colored person. And then the 14th Amendment comes around and says, wait, some United States citizens are white. So that's discrimination. Within that class, some people are born in the federal territory are white. So to have the word colored person in front of that is discrimination. So you got to take out colored. So now it says no person shall. So then prosecutors, they go nuts now. They're just like, oh, we'll charge everybody with it now. We'll charge black people, we'll charge white people, we'll charge all of them, because we're just going to all assume that they have limited protections. We're going to make that presumption. And the court's going to err on the side of the state unless something else is brought forward to prove something different. So they start making these presumptions about people. And they start applying these laws that got watered down. It used to say colored person. Now it just says no person or any person. So now we're sitting here and there's this big tug of war, right? On the one side of oppression, there's the psychopaths who are willing to fight with anything, are willing to win by any means necessary. To them, the ends justify the means. I want to oppress people. I need to oppress them so I can have an economic advantage. The country can't grow unless we have free labor. I'm holding on to what my daddy told me. And then on the other side of that, you have people fighting for liberty. These are white people, these are black people, these are from the North, people from the South, they're from all over. And what they're saying is that no, all men are created equal. We're going to live true to what that doctrine said. We're going to live true to what the Declaration of Independence said. All men are created equal. So on one side, they're tugging, they create these black laws, and they pull really hard, and they get people, and they start to fall over the line. And then, last-ditch effort, they pull back. They start creating these organizations, the NAACP, the National Association of Colored People, the NRA, National Rifle Association, was originally created to protect the rights for black folks to bear arms. That's why it was created. Black folks demonize it now as if it's the devil reincarnate. But it was set up to protect their rights to bear arms, to defend themselves, to defend their life, their property, because in their eyes, you all have a right to life, liberty, and the pursuit of happiness. But that's not what the law said, not the presumptions that are being made about you in the law. Because everybody was confused. Nobody understood it except the people who crafted it. Because everybody was always only subject to the common law, they didn't understand the process of how to get out of the fact when you were charged by something other than the common law. In England, it was clear because you had commoners who weren't exclusively subject to the common law, and you had lords who were. So they had developed processes to fight through it. Here, everybody was a lord until the 14th Amendment came around. Then again, you had lords in the states, serfs in the federal government, or in your state based upon residency. So now we're sitting here and we're confused, right? They don't know how to fight their way out of it. So the psychopaths, they essentially pull over the line one more time. So they pull and they yank everybody across the line. So now everybody's on the side of oppression now. They've tumbled down, they've fallen over, they spun around, they don't know where they are, they're disoriented. They're on the side of oppression. So then they start coming, they say, we got them down now. We got them down now. They create all these organizations to protect themselves. We're going to come with prohibition. We're going to come with gun control. We're going to throw all these things at them because while we can't take away the guns of a citizen in a state, we can take away a gun of a United States citizen. We can take away the gun of a citizen who is a resident in that state, or a citizen by residency, not by birth in the state of a union. We can take away those guns. So they passed all these laws. So now we're standing under the weight of oppressive legislation with no idea how to get out of it. And then it just becomes so commonplace that now the NRA, they're not fighting to protect the rights for minorities to bear arms. They're fighting for the right to protect everybody right to bear arms. Because now it's not seen as a right, it's seen as a privilege. But when the Constitution was written, it was plain and simple. For so long, everybody thought that, it's in the Bill of Rights. We got a Second Amendment right to bear arms. Over 200 years ago, the Supreme Court specifically stated that the Bill of Rights only protects individuals from the federal government. It doesn't protect them from state legislation. Now, through these 14th Amendment citizens, they have selectively incorporated aspects of the Bill of Rights because they became citizens in 1868 and the Constitution was written in 1787, and it didn't contemplate them, none of that applied, but the court has decided that we will selectively incorporate aspects of that to determine what your rights are. So now, here we are, and we've lost sight of the fact that Article 4, Section 2, Clause 1 of the Constitution is the clause that protects our liberties from the encroachment of the state governments. So now we go into federal court and say, it's a violation of my Second Amendment right to bear arms. And the court says, no, it's not. The state of Texas can write any law that they want to. And the Second Amendment doesn't protect you. Now, when we invoke Article 4, Clause 2, Section 1 of the Constitution, we see that now we have to state who we are. I'm a state citizen. What am I entitled to? I'm entitled to my privileges and immunities, the right to life, liberty, the pursuit of happiness. I'm subject only to the common law. So gun control doesn't apply to me. Prohibition doesn't apply to me. Possession doesn't apply to me. Unless you can show me damaged property or an injured person, then there is no conversation to be had. This is what the law said. The Supreme Court says this. I didn't say this. I didn't make this up. This has been the case since the Magna Carta, 1215. Why all of a sudden would it be different now? There's no reason for that.